being here. Good afternoon. I'm Wendy Goldberg. I'm the Executive Director of the Trifaith Initiative, and I would like to thank you all for joining us for this conversation. It's been a while since we've had an open heart session, but I think it's important when this United States Supreme Court makes a unanimous decision, particularly on a conversation that connects to our mission of religious freedom and celebrating religious pluralism, that we gather and have a conversation. And hopefully that will be a signal to all of you to realize that this is something that we aren't going to have all the answers about today, that we want to invite curiosity about, and that we know that it invites conversation around it has a lot of implications that are difficult conversations, but this, because it was a unanimous decision, is kind of a safe space for us to explore what we mean when we're questioning the accommodations and the outcomes of a decision, the implications of a decision that impacts both the majority religious folks and people at the edges of understanding in terms of their accommodations or welcoming in public spaces because of their religious identities. And so thank you for joining us. We will at the end invite questions, so keep in mind as we go that we will welcome your questions, and we would ask you to put those in the chat. I would like to start by inviting the panelists to introduce themselves and share a little bit about their professional background, the expertise in the field of religious accommodations in the workplace, and kind of why do you think we invited you to come here today? I'll start with my colleague, Jeremy.
Hi there, Jeremy Fricke. I'm the Vice President of Mission Advancement at Trifaith Initiative. I have about 10 years of experience working with religious diversity, equity, and inclusion, and have a background in both human resources and religious studies with a minor in pre-law. I am not a lawyer. That's why we have all these wonderful people here on the panel with me too. But I'm just really passionate about this. So, and it's very important to me for us to make sure that workplaces allow particularly religious minorities to be themselves the way that they wish to be.
Thank you. Marcia.
Good morning, I guess good afternoon. I'm Marcia Washkoon. I work at QTech Rock. I'm an attorney there. I head our employment law practice, and I also am the firm's employment attorney. So I provide advice and counseling to employers who have questions about all kinds of employment law issues, including religious accommodations. And also I litigate cases as well. I am on the management side. So as I mentioned, I provide guidance to employers typically, and would be helping them in the religious accommodations front, flag issues, and make sure that they're doing their best to comply with the law.
Thank you. Catherine?
Hi, I'm Catherine Cano. I'm a partner with Jackson Lewis Law Firm. We're a national law firm, but we have an office here in Omaha with about 30 attorneys. And like Marcia, we are on the management side of things. Our firm only practices in the labor and employment space. And so we all dedicate our time advising employers and defending employers when there are employment disputes. And part of that does involve helping them assess and work through religious accommodation issues. So I've been with the firm for about 10 years, and that's been something we've advised on, or that I've advised on since I've joined the firm.
Thank you. And Rachel?
Hi, everyone. My name is Rachel Lazar. I'm the president and CEO of Americans United for Separation of Church and State. We're a national nonprofit, been around for 76 years, and we bring together religious and non-religious Americans to fight in the courts, across state legislatures and in Congress, and in the public square for everyone's right to believe as they choose, so long as they don't harm others. And today we're spending a lot of energy fighting religious extremism and an ultra-conservative political agenda that is cloaked in religious freedom, trying to keep religious freedom as the sacred and pure and protective shield that it was intended to be, and to stop it from being weaponized as a sword to harm others. I am a lawyer by training, and I've worked on and thought about issues of religious accommodation in the workforce, both at my time as the deputy director at the Religious Action Center of Reform Judaism, and of course in my role as the president of Americans United, where we submitted an amicus group brief, a friend of the court brief, in the Groff case to the Supreme Court.
Thank you. So again, I am no legal scholar. I'm just going to give a very brief overview of what happened in the Groff DeJoy case, kind of place setting, but please to our more learned folks, please add on to anything I don't say here. But my understanding is that when Gerald Groff took a case as a mail carrier for the United States Postal Service in 2012, he was and is still an observant Christian and felt that there was not a problem posed related to his observance of the Christian Sabbath on Sundays. But after USPS started doing business with Amazon a year later, his religious observance became an issue. And in rural Pennsylvania, his bosses often found a way to accommodate for his time, but his colleagues grew weary of him of taking his shifts, and he was instructed to report on Sundays. When he refused, he drew letters of reprimand and suspension, and eventually in 2019, he quit. After resigning, he sued under Title VII, alleging that the USPS could have accommodated his Sunday Sabbath practice without undue hardship, and he lost twice in the lower courts. He claimed that USPS had violated the bar on religious-based discrimination of Title VII of the Civil Rights Act of 1964. I said that wrong, sorry. And I don't know how I got 2064 out of that. The case rose to the Supreme Court, and after he, as I said, from rural southeastern Pennsylvania had sued the post office, he argued that the job did not allow him to observe the Sabbath and that he was punished when he did not work on those days. The court in this case clarified a previous legal standard that required employers to demonstrate a minimal cost or de minimis cost to deny workers' requests for religious accommodation. And it now says that the employers must show that the burden of granting an accommodation has a substantial increased cost in relation to the conduct of its business manner. We'll talk about that much further. The Groff versus DeJoy is an example of a case in which the Supreme Court clarified an earlier decision, and we'll talk about kind of the differences in this clarification during this panel to understand explicitly the topic of undue hardship. And I think also furthermore, the Justice Alito's opinion that says that, and this is a quote, "A bevy of diverse religious organizations has told this court that the de minimis test has blessed the denial of even minimal accommodations in many cases, making it harder for members of the minority faiths to enter the job market." So for clarity, Jeremy, if you could start and talk a bit about how at Trifaith we intentionally define or don't define religion and tell the audience about our practice.
Yeah, so I actually think our definition of religion is pretty actually in line with some of the legal definition in a sense. In a sense, we actually don't really fully define it. There are kind of 5 ways that we see religion impacting people's lives. The first being belief. We kind of call these the 5 Bs, by the way. The first being belief, which is really those thoughts and emotions around religion. The second is behavior, which is the rituals, practices, and performed ethics of religious communities. The third is belonging, which is the connections and communities we're a part of. The fourth is becoming, which is the changes that people may make throughout their lives or throughout the year, basically being able to be open to people's continued stories. And then the fifth is body, and that is really the way that religion interacts with our other identities, our race or gender, sexuality, sex, or various other types of identities.
So that's kind of a long way of saying we are not in the business of telling other people how to practice their religion. Is that right?
Absolutely. It is defined by how people define themselves.
And why is that important?
Well, there's two main reasons. One is that we believe that the ability to be religious or to participate in religion or spirituality, which I use interchangeably, is housed at its core at the individual level. And it is an individual right in the United States to be religious, whatever that may mean. We'll talk a little bit more about that probably pretty soon too, but I think it's very important for us to be open to the idea of people just being different and not necessarily fitting in the box of what we understand to be religious all the time. It might be defined differently based on the person.
Marcia, I'll ask you kind of the same realm of question next, but related to workplace law. How are you defining religion and perhaps related to the Constitution as well?
Well, the law defines for us as lawyers what religion means, and it's pretty broad, just as Jeremy described it. I would say it's pretty individualized. It's not necessarily always a traditional religion with specific practices or beliefs that you might even be able to locate and identify with any particular structure to it. So it can be something very non-traditional, oftentimes something very specific or unique to the individual that you may not understand. And oftentimes you would have to do your own research to determine if in fact you can locate anything on it. But just because you can't understand it yourself, or it's not a traditional belief that you've heard of before, doesn't mean that it won't be in the law considered a sufficient religion. And in fact, non-religion or atheist beliefs have been construed to also fall within that concept as well. So it's really very broad in terms of the law. And if you haven't heard of a person's particular religion before, it doesn't mean that it won't be something that has to be either protected without discriminating against it, or as we're talking here today, needing to be accommodating if there's a conflict with the person's religious belief and a work rule.
Thank you. Rachel, I imagine you spend a lot of time talking and thinking about this. What would you add?
I guess what I was thinking about when others were talking was Ruth Bader Ginsburg's line. Justice Ruth Bader Ginsburg was one of my heroes, Shiros for sure. And she was fond of pointing out the limitations of freedoms, because in America, we love freedom, but we love equality just as much. And so when someone's freedom starts to be exercised such that it's interfering with someone else's freedom, right, then we need to think about where there are appropriate limits. So the line that I actually just looked it up, but one of her famous, she would talk about this a lot, actually, like in her dissents in particular. But here's one place where she said it. She said, in sum, with respect to free exercise claims, no less than free speech claims, your right to swing your arms ends just where the other man's nose begins. So I guess I just wanted to introduce that concept. Legally, I think sometimes the way we try to portray it is, you know, the Constitution has two parts of religious freedom: the free exercise clause and the non-establishment clause. And they coexist in this healthy tension, and they work together to protect everybody's religious freedom, right? That's the purpose of them. And so the idea is, if your free exercise is something that is standing in the way or imposing costs on me, it's interfering with my ability to live out who I am in my religion, right? And that's a problem. That's the government letting you establish your religion over mine, giving favor to your religion over mine. And that's a problem legally.
Thank you. Catherine, I want to give you a chance to add anything you want, but also kind of add the next definition in so that we can continue the conversation, which is in defining undue hardship or de minimis. Please add anything you want about the definitions, but if you could take us to the next place, that'd be great.
Of course. And I think from an employment law standpoint, Marcia covered the definition of religious that we deal with very well. Like she said, it can be a minority belief within a religion. It doesn't have to be an organized faith or recognized faith. There's a lot of, because it is very individualized. But in terms of undue hardship, so undue hardship is not a new concept. We've been dealing with that phrase for many years, and that's, the law says that an employer has to provide a reasonable accommodation for someone's religious beliefs unless it imposes an undue hardship on the employer. And so we have old case law from the 70s, and this is the rule we've been following for the last, almost 50 years, said that for purposes of religious beliefs, that undue hardship is a de minimis burden. And de minimis, like it sounds, I mean, it's a minimal burden, a minimal showing by the employer that there's some sort of, cost or burden to it. In this decision in Groff, the Supreme Court has said that really undue hardship for purposes of religious accommodation should be defined differently, that it should not be a de minimis burden. It should be, as you said, the substantial increased cost in relation to the conduct of the employer's particular business. So unfortunately, we don't have like an easy bright line rule. It's still going to be an analysis and depend on for what organization may be an undue hardship, may not be for another organization. It's going to take into account probably things like the size of the employer, its financial strength, things along those lines.
Anybody want to add anything to that definition before we move on? All right. So I feel like it's kind of a big deal that this court made a unanimous decision. But the question is then, is this a religious takeover of the workplace? Rachel, I'm going to let you answer first.
I don't think it's a religious takeover of the workplace. I don't think that this is a sea change or like a hallmark decision. I think it really is more of a clarification, because even in that TWA versus Hardison old case that established this de minimis harm standard, it used it interchangeably with substantial cost to the employer. And so in that regard, I think it might tweak it around the edges, in favor of religion in the workplace. But I think it was incredibly important that, that the court found that an employer needs to take into account things like harm to fellow employees, or even if you think about it, harm to customers. I mean, I think it's very lawyerly, I know, to focus on the exact words of the test. And that's why, like when Catherine just looked for like, what were the exact words? We care about the exact words, but, the conduct of a business also, I think can be, it's intentional words, right? And it references the inner conduct of the business as well and how it is to work there. I think it can reference the reputation of an employer as well. And I think that overall, it's a good thing that this is a factual analysis and that we don't know, and that it's very contextual, because this is a very contextual thing. I'll say one more thought before I pass the ball, which is, I think this was a case where the interest of big business was pitted against the interest of religious accommodation and religion. And this is a court that's incredibly sympathetic to both of those things. And I think that could be why what we saw in the end was a more tempered decision than we could have, right? Because of that tension in deciding for either side. I just thought I would note that, Wendy.
Thank you. So related to this religious takeover in the workplace, Catherine or Marcia, are you concerned at all about or hearing from your clients questions about this decision yet? And any beginning thoughts on whether this will be a religious takeover in the workplace?
I'm definitely getting questions. I think that although we may not have a complete sea of change, I do think that we will see probably an increase in the amount of religious accommodation requests. I think with the standard before being lower, I mean, we know that this is a higher burden now for employers, that maybe we will see more employees that feel comfortable requesting accommodations in the workplace, and it's going to be a more, I think it's going to take more analysis on part of the employer than it did before.
And I would just add to that, my personal belief is it hasn't really changed the process too much. And it always has been a case-by-case analysis. This decision makes it clear that it's supposed to continue to be that way. But what I think will be the change more than anything is larger employers in particular will really have to be careful. The more than de minimis cost language that was taken out of the Hardison case that this Groff decision clarifies was incorrectly used as the standard, because it was just allowed for any kind of trivial cost to be sufficient to deny a request. That now employers will have to go through similar process, but they have to understand that they really need to be careful about denying a request. And if there's, they always have had to establish it as a defense themselves. That didn't change. So the process hasn't changed. And the case-by-case analysis hasn't changed. It's just the burden on the employer to prove that there is an undue hardship is what's changed. It's a much higher threshold than it was before. It is lower than the ADA, which is the Americans with Disabilities Act. The court made it clear it didn't adopt that threshold, which is higher. But the employers now will have to make sure that they are looking at the cost to the business and documenting that cost, making sure they can prove why it is that they believe they have more than a substantial increase of cost. And it doesn't have to just be economic costs. It could still be some soft non-economic costs in terms of lost productivity, customer complaints, if they are going to have increased safety problems as a result of denying accommodation or be unable to comply with regulations applicable to their industry. Those will all still be relevant and need to be documented. And I think those will all still be bases to deny requests. But I think the change will mostly be where there's not a large impact and you can't prove the impact easily. For example, I think grooming policies are going to see the biggest change, because I think the de minimis standard was used by courts to basically say employers have a lot of freedom to define what they deem to be professional standards. And I don't think that will cut it anymore. And I think that also the language in the opinion suggests that just because somebody may be offended by somebody's religious practice, that to me applies when you're dealing with grooming standards, and consumers maybe being worried or people perceiving something about a particular religion. That's not going to cut it anymore, I don't think. Whereas in the past, I think courts have found employers' grooming standards sufficiently enough to deny accommodation requests. So I think that'll be one of the bigger changes. I think
Marcia,
another
for those of us who are not in the legal lane, can you define grooming standards for us?
So employers will often have policies related to, let's say, dress code. That's probably a more common term, but a grooming standard can include a dress code, what you would dress like in the workplace, but it could also include hairstyles or facial hair, whether or not you can wear anything on your head, that kind of thing. Sometimes you have grooming standards that are based on safety requirements, and some of that might be just the employer's safety requirements, but some of it could be by law. There might be OSHA standards, for example. A lot of the standards in the healthcare field, for example, could be based on safety requirements in terms of having to groom a beard sufficient enough to be able to wear, a mask for purposes of keeping people safe from infections, that kind of thing. So those are grooming standards. And if they're not based in safety requirements, I think you're going to have a harder time explaining how those would create a substantial increased cost to your business as a justification to deny accommodation.
And even some of those safety standards may be into question, because not if it's a binary question of whether this is unsafe or safe, but I think of like particularly during COVID, a lot of Sikh nurses and doctors who grow beards. There are masks available that work with facial hair. The question is it expected for people to pay a little more for those employees to have that opportunity to have those safety masks, or is it too much? Is it too expensive? I think, that's when it's going to get complicated with smaller organizations versus larger organizations and exact specifics of the situation. But in the past, it seems like it was fine to kind of let someone go if it was going to cost something.
Right. And I think that this decision makes it clear that just because you have some administrative cost or maybe overtime that would be required, or incentive pay to get people to work hours to allow somebody to exercise their religious freedom on their Sabbath, let's say, it's now going to be much harder to use a small cost financially as a basis to deny the accommodation. And the smaller the business, the easier it will be to establish, but the larger, the much more difficult it will be to establish. And then you'll need to, I think, really, the employers will really have to document the justifications and the costs. And if there's a safety concern, it can't just be presumed. It's going to have to be, I think, demonstrated with science, or if you're worried about wearing loose clothing in the manufacturing environment, what does the manufacturer's, guidelines say about that? How many injuries have you had in your workplace? You're going to have to really prove with evidence. We're always supposed to, but now the burden is just higher.
Thank you.
And Wendy, I can say something off of that if we have time.
Please.
I think it's so important to always be aware of the power dynamics, and I think that I bet all of us, right, would agree that if it gets easier for someone to wear facial hair because that's part of their religious beliefs, even if it's a little bit of a cost to an employer, or, for someone for someone to be paid to cover a little bit, right, occasionally overtime, so someone can work on Yom Kippur or, Easter or whatever the days are, that's a good thing. That's a good thing, for society and like for the diversity that we're trying to support. And that's very intentional in America, and that makes us all proud to be American. I think it's again where we're talking about the law allowing people to use their religious beliefs to harm others, where we also would all agree that we don't like that. And the reason that I say that pretty confidently is we did polling and we saw that 79% of Americans agree that the law shouldn't allow anyone to use their religious beliefs to harm others. And that's what we're concerned about these days. So I just want to reference an interesting study that was done that Adam Liptak has written about a few times in the New York Times. And the study was done of all cases that have gone before the Supreme Court involving religion by a couple of, I don't know whether, I forget the field that the two people doing the study come from, but I do know that one of them is Judge Posner's son. So I know Posner is one of the names on the study. And the study found that under the Chief Justice Roberts Court, that the court has ruled in support of religion over 80% of the time. And that's as compared to around 50% of the time in all previous eras since 1953. But what's also really significant about that change, just speaking of power dynamics, is that whereas the court used to rule in support of religion where it was in defense of a religious minority, now almost every single one of the cases where the Chief Justice Roberts Court is ruling in support of religion, it's in support of Christianity. So the majority religion. And I also wanted to point out along those same lines of power dynamics that the folks who brought this case on behalf of Groff are First Liberty Institute. And First Liberty Institute is unabashedly part of this shadowy billion-dollar religious extremist network in America trying to use religion to license discrimination. They were the ones who brought the Coach Kennedy case, the praying football coach case that my organization argued in the Supreme Court and lost, unfortunately, in defense of a public school football coach that pressured the public school players to pray with him at the 50-yard line. They brought the Carson v. Macon case that forced Maine taxpayers to fund religious education. And now that it's being contested whether that decision forced Maine taxpayers to fund religious discrimination, now First Liberty is back defending the schools that discriminate in court. They also testified in Texas this year in support of the bill that almost became law that would have forced all Texas public school classrooms to display the 10 Commandments. So just to be clear again about the interest and the power struggles here, that what we're spending a lot of time watching at Americans United for Separation of Church and State is this effort to license harm to others in the name of religion. And while this case in the end didn't do it, which was a good thing, a companion religious case called 303 Creative that you might have read about, the graphic designer in Colorado, did exactly that. So that's my little spiel on power dynamics. And I wanted to make sure that that was unearthed in our conversation.
Thank you. It certainly opens the conversation and container that the people are asking questions in the chat. And somewhat some of the next question that we had thought about. Sincerely held religious beliefs are protected in the workplace. Are there any concerns or challenges that arise when determining what is a sincerely held belief? You know, Steve is asking as an atheist, and if there are coworkers who are also impacted, well, you know, will we be honoring those who are non-religious and their accommodations for days off? Jeremy, I'm going to let you kind of start off this conversation, and then we'll let the rest of the panelists weigh in on the implications. Obviously, it intersects with the reality that most religious accommodation claims come from minority religions as well. And so if you could kind of weave that reality into the response, that'd be helpful.
Yeah, so, okay. So firstly, when we're talking about the sincerity of beliefs, I would, from a DEI perspective, I would encourage people to avoid worrying about the sincerity of the belief unless that is the last thing that you look at. You should always be looking at, can this accommodation be reasonably granted to those who request it? Can this, is this do I understand this well enough to know how often this will happen, or how this might impact other workers and things like that? So I would always start with the accommodations before the sincerity of belief. In the, I believe it was it Sotomayor with the concurring opinion, but there's always the question of exactly how this will play out for non-religious communities. This case is fundamentally about religious rights in the workplace, and those who do not see themselves as requesting religious religious accommodations are not necessarily directly impacted by this decision. But I would strongly encourage the first process is to create policies and procedures that are flexible enough and inclusive enough that people can make their own decisions around this, whether it's for religious reasons or not. Yes, there are always questions about exactly what the legal rights are to someone on the basis of non-religion in this situation. But generally, as many of the other panelists have held, secular worldview, if accommodation is needed for secular worldview, that is also able to be seen as a religious accommodation. It's, we often define religion more as how people relate to religion, rather than, the identity of religion. So, and to some extent, that is how I would encourage people to think about their equity and inclusion practices, is how can I make space for people regardless of how they relate to religion, again, rather than just focusing on whether their identity has a clear name or whether it has a clear community or has a clergy person or something like that.
Catherine, as an employment lawyer, how do you see this shifting your advice?
Yeah, sorry, my light went off. I guess I wasn't moving. It's emotion censored, so I went dark there for a minute. And your question is I don't think that the decision doesn't impact the definition of religion. The definition of religion under Title VII has been the same, and that has always included minority religions. In terms of when you're looking at assessing the sincerity of someone's religious belief, I can tell you the EEOC's guidance says that you should generally, from the employer standpoint, assume that it's a valid and sincerely held religious belief, and not to get into questioning it. However, there are some situations that can arise where it maybe looks a little bit suspicious to the employer. Like if you have an employee who's asking for some sort of an accommodation, it doesn't tell you that it's based on any religious belief, and after that's denied, then comes back and says, oh, well, I should have told you it's related to religion. Maybe that's something that raises the employer's suspicions a little bit, or it can be really tricky if the religious accommodation is kind of tied in with something that's viewed as favorable. We talk about scheduling. A lot of people don't like to work weekends. And so, there could just be a lot of different factors out there for why an employer may feel like they need to get a little bit more information. But I think at bottom, because the definition of religion is broad, the employer needs to be careful about how far they want to push on that. They can certainly ask some clarifying questions in most cases, but you want to be sensitive to everyone's legal rights, frankly.
Marcia, do you have anything to add specifically to Steve's question about whether there'll be any change in honoring a request of a day off of someone who identifies as an atheist?
Well, I think Catherine talked about the sincerity piece of it. And the religion definition hasn't changed. I agree with all of that. I would add, though, you do still have to have a religion. So it has to be religious in nature and sincerely held. So the first question I think the employer would ask there is, what is the belief? What is your religion, and what is the belief that conflicts with the work rule that you're seeking accommodation from? And there certainly is ability to ask about that. And if you have a belief that is a religion, and it's based in religion, then the next question, if it's sincerely held. So I think that's the question. Is it a religious belief? You might have legal rights to not want to work a certain day, or to disagree with the fact that somebody could get a accommodation due to a religion. But if you want to have an accommodation for your own religion, you have to show that your belief is a religious belief. And if you have an economic, a political, or a social basis for your belief, that is not going to be sufficient. It has to be religious. And that doesn't mean it has to be traditional, as has been already said. And it doesn't have to necessarily be something you can verify. It could be very individualized, but it has to have some kind of moral or ethical basis similar to more traditional religions, I would say. So I would say, I'm not going to speak to whether Steve would have a religion he could put forth, but that would be the question, I think. And I would recommend typically, and I think this will be more important now, having a form that employees fill out. It's not required that employees ask for accommodation in writing, but if you do have a standardized process, which will ask about the religion and how long they've been practicing and what the conflict is, and ask some general questions so that you can get an understanding of, as the employer, if it's a religious belief that's sincerely held, I think that helps make sure that you're not probing too much and treating everybody consistently as well.
So I feel like there's still some question out there between Joe's question and Steve's additional comment as to whether or not atheism will be recognized as a sincerely held belief. Jeremy, I see you turned your mic off, so you must have something to add.
Well, my understanding is that, I mean, in many cases, the atheism itself has been seen as a religion. And it looks like Rachel also said that. And really at its core, again, my understanding is that you are protected for the sincerely held religious belief, which is a little different in some ways than protected on the basis of your religion. And why I say that is because that's where we get back to, technically, you as an individual have a legal right to religious freedom, even if your religious beliefs only apply to you. Now, it does become difficult. I mean, the truth is that historically people have denied and gotten away with denying people's individual religions at a higher rate than people who are part of large religions. And I think that is a problem to me, in part because I don't think that we should have to fit into the boxes. You know, maybe, you know, I go to this religious establishment, but maybe I believe in something that technically that church doesn't preach, right? I still should be able to have the right to follow how I understand it. So, I mean, it would be, to me anyway, like, I think you need to be able to describe why you would have that particular practice on the basis of your sincerely held religious belief, because that's you know, it's a workaround way to show sincerity in the forefront, is if you're able to describe why.
Can I add just a quick point to add? Maybe I think this might be the disconnect. And Marcia's mentioned this a couple of times. So she's mentioned that there has to be a conflict. So it's not just that you have, I think also to Jeremy's point, it's not just that you have a religious belief, it's your religious belief has to conflict with some sort of work requirement. So if it's a scheduling piece, you would need to show that you have a religious belief that conflicts with you being able to work that schedule. And so I think for atheism, for example, where you would still need to be able to show how your beliefs as an atheist conflict with you working certain days of the week. It's not just, you know, that I'm Christian, so I don't want to work certain days of the week, right? It's if they're trying to tie it to the Sabbath, which was like what we had in the Groff decision, it was to attend, maybe it's to attend religious services, or it's considered a day of rest, that type of thing. So that's where the religious belief actually conflicts with the work requirement. That makes sense.
Thank you. Rachel, did you have anything you want to add?
Just that I'm not an employment lawyer, but that I was thinking about how one of America's greatest strengths is the way we allow different religions to flourish. And there's supposed to be more than 2,000 on our shores today. And religious freedom is the right to change your religion across the course of your lifetime, to concoct your own spiritual brew. That's a good thing. And I was thinking that therefore our society and our courts appropriately have been very deferential to when someone says, well, I have this as my sincerely held religious belief. And that overwhelmingly is understandable. It's, you know, maybe it's one of those cases where, like, you know, your greatest strength at a certain age becomes like also your weakness or something. But, you know, it's like when we're in the day and age of pastors putting up, you know, businesses to write excuses for people not to get vaccines, you know, so people can sort of opt out of vaccines. I mean, in those cases, you know, we could spend all of our time and energy questioning, is that really a sincerely held religious belief? But what I would say is just go to the cost analysis, right? Like religious freedom is not the right to risk people's lives. For example, in your workplace during a global pandemic, say. And so I think that fortunately, usually we can move past it could be my religious belief that I have to speed on Sundays if I'm late for church. But I don't care if that puts other people's lives in danger, because that's like my religion is so important. If I'm not there with God at 9 o'clock, I'm out. And I could make that argument, I suppose, but and again, this isn't about workplace, this is about society, but we don't want to be a society that allows people to put other people's lives in harm's way. And so again, I think, it's interesting to think more than we do probably about sincerity, because it's being abused today, but also it's the next step of the analysis, I think, that we can also often use to cut off where there are abuses.
So let's talk practically about what some of the accommodations that you see as attorneys in workplace law. Part of my question is, how far does the obligation of an employer extend when accommodating these kinds of requests? Are there limitations or exceptions? What are some examples? We've mentioned a few. Are there others of kinds of accommodations that are coming up, and where are those edges? Marcia, do you want to go first?
Sure. I've already mentioned a couple, and we've been talking about scheduling a lot because the Groff case involved scheduling. And scheduling can be not working on a particular day, but it could also be taking breaks to pray. Differences in terms of flexibility to attend different types of kind of church related or religious based activities. So you can ask for all kinds of different scheduling accommodations. The grooming accommodation is another big one, I think, because you can have people who have religious garb that they are required to wear, or engage in, have different types of articles on them as part of their religion. And so I think those are the two biggest areas where you see accommodation requests, I would say. I don't expect that, and then I'm sure there are others I haven't fully flushed out, but those are the two biggest areas, I would say. And on the fringes there, like I said before, I think that the impact this case will have is mainly in those areas where there's minimal financial cost that in the past was viewed as sufficient because it was more than de minimis, in either helping with scheduling, because there's actually a reference in the opinion in a footnote to several cases where there are references to some minority religions and how courts held very minimal burdens on the employer were found to not have to be accommodated. And so that footnote with those cases is really important in my mind, because it shows the court's decision and intention is to ensure that those religions and those types of accommodations are actually granted. And the biggest one in my mind was referencing the Walmart decision in 2021 from the 7th Circuit, where basically Walmart, which the court noted is it makes $11 billion annually, didn't have to help with organizing scheduling for voluntary shift changes because that was too much of a cost. I don't think that kind of cost will be too much anymore, particularly for large organizations. I think the employer will now have to in finding volunteers to help with voluntary shift swaps when it comes to scheduling changes.
Anybody else want to weigh in on that question?
Just that if you have a religious conversion once you've already taken a job, that actually was the case here. In Justice Alito's opinion, I just have it in front of me, he points out, after taking this job, about the Hardison case. Hardison underwent a religious conversion and he began to observe the Sabbath, and that's the underlying case that was clarified and not changed. So even if you do change your religion throughout your job, your employer still has to accommodate. I mean, you still have to perform the basic functions of your job though. And that was one of the problems here in the Groff case, where the guy was hired as a flexible part-time postal carrier. And Sundays became one of the need to be flexible and cover days. And his 3 coworkers in his office were also church-going Christians, and he missed 24 Sundays. And by the way, I never know whether to throw this in, but the record formally reflects that he was also watching NASCAR in the afternoons after church. And like the employer tried to work with him and say, maybe you could work half the day. And anyway, he needed to watch NASCAR, but I digress. Maybe I don't. But his coworkers in this case were really harmed. Like, I think, in this contextual analysis, they filed grievances, they asked to be transferred, they left their job and they protested. So here, I think we had a pretty clear-cut case where there was harm. But I just think it's important to remember that once you take a job, that you can still be free as a human being to have a conversion that requires you to have different needs. And of course, if you can't perform the basic job, that's a problem. But if, as we've been talking about, Wendy, if the employer can accommodate without a substantial cost, then,
But it's important to point out too that we've been talking a lot about the burden changing and being better for employees in terms of those who have conflicts because of religious beliefs. But the court remanded to the lower court to actually apply this standard. And while it's pretty clear that just burden on the employees alone is not enough, if the employees were unhappy or disgruntled or maybe even made complaints, that may not be enough. But if that impacts the business substantially enough, because say the employees are leaving and it leaves the individual, the employer unable to actually operate its business sufficiently or productively, then that could be enough. So I would assume that it's possible here for the employer to still prevail, but it is a large organization. And I think Justice Sotomayor mentioned that there would need to be evaluation of the cost for coordination potentially with other local rural areas. So there's just a lot more analysis that will have to be done at the lower court level.
That was the same point I wanted to make. It's not like this decision is saying anytime you have a religious accommodation request related to scheduling, employers have to grant it. That's not what this is. It's just clarifying the burden that the employer has to show to be able to deny that request.
Yeah, and just like a minor side note here is, like I know someone who asked for winter solstice off about 3 months in advance, right, before this case. And they were denied because that's during the Christmas season, right? They were pagan. They were asking for a religious accommodation. I think in this case, they would have had to, in some capacity, see if there was an alternative for her at that time. At least that's how I read it. But the first time around, it could have been argued, well, it's simple that this was a mandated time and there really isn't any way to do this without an additional cost. And that minimal cost is almost always, it's not hard to pass the minimal cost.
Thank you. So a closing question that I'd like each of you to take a minute to answer is, what are some best practices for future proofing religious accommodation? What advice do you have from your expertise? And Catherine, how about if you get us started?
Sure. I think Marcia mentioned having some sort of standardized form. I think that can be really helpful. I just would like to raise that as one thing. It's not required that you necessarily have policies that address religious accommodations, but I think it's best practice so that employees know what they're supposed to do if they have a religious accommodation request. It doesn't need to be extensive, but have something in your employee handbook and your EEO section on that. Potentially providing some training around religious accommodation requests for supervisors if they're going to be dealing with those requests at all. And then I would just keep an eye out. The EEOC is the federal agency that's responsible for enforcing these laws. So if an employee thinks that they have been wronged, they go and they file a charge of discrimination with the EEOC. So the EEOC's guidance is not necessarily binding on courts, but I think it can help, especially when we're getting like a new test like we are here, it can help you at least understand how the agency is going to view this topic. There's existing EEOC guidance, and a lot of it probably won't change. I would suspect the EEOC might do some updates, but that's always a really good resource if you're kind of in a sticky position, is to go to the EEOC website and just look at what they have, what their recommendations are. They give question answer type guidance, and they have a lot of resources out there. So those are my takeaways for employers.
Thank you, Marcia.
I would just add that I think it's a good idea to have a centralized person who's very knowledgeable. So Catherine mentioned training, and I'm all in favor of that. I think supervisors and frontline managers have to know what they can and can't do, but also, even if somebody doesn't specifically ask for a religious accommodation or use those words, if they become aware of it, they need to know what to look out for, especially considering that some, we're also dealing with non-traditional religion in terms of needing to make accommodation. But if you have an HR department, somebody within the HR department should be looking at all of the accommodation requests and really make sure they're trained. The EEOC does provide also training, and I suspect they'll probably have training resources available for this decision in particular. And then this is a retroactive decision in that it's not just forward looking, because it's clarifying how the standard should have been completed and evaluated. So if you've had any recent, if you're an employer and they have any recent denials, they should probably go back and people still in the workplace, see if they need to revisit those.
Rachel, thank you.
Yeah, I mean, I think I'll leave the advice coming from the good employment attorneys to you all. I guess I'll just use my 1 minute to say that today, unfortunately, we are really living amidst a moment where we have a emboldened movement that is trying to misuse religious freedom to advance a very scary agenda that turns the clock backwards in this country and takes away rights from a lot of us, including religious minorities, racial minorities, LGBTQ people, women, really, like, to the extent that we're all multifaceted in our identities, sort of all of us in a sense. And so what we're calling for at Americans United is a national recommitment to separate church and state. And we like to remind people that there's nothing anti-religion about that at all. It actually protects everyone's religious freedom and everyone's ability to believe as they choose and to live as themselves, not according to someone else's religious dictates.
Thank you. Jeremy, wrap us up.
Yeah, so I'm gonna post a few questions in the chat also, but I'm gonna kind of say them out loud. Ask yourself, do you have a clear process for someone does need an accommodation, a process that is inclusive for a wide range of religious and non-religious diversity? Are the policies and procedures inclusive enough to where employees can help make decisions for themselves? That is part of the track to work with non-religious communities as well. Are they malleable enough for those who you don't know yet, right? That you don't know enough about religion quite now, but let's make sure those policies work. Do you know enough to know that you're not discriminating? There's another case, EEOC v. Abercrombie and Fitch, that really drives home in some ways the idea that ignorance is not a defense when it comes to discrimination or on religion in the workplace. You should know enough to know that you're not discriminating. And are you communicating these things both internally and externally to every employee that you hire, that these opportunities are there? not targeting particular people or anything like that, but communicating that these accommodations are available, that this is how you feel and how you're intending for these policies and procedures to work, and that you're showing that your organization is an inclusive space for all people.
Thank you. Thank you, everyone, for showing up today. I hope that it was a good use of your hour, and especially to our knowledgeable panelists. Thank you for offering your wisdom and helping us to find our way through gaining understanding on this kind of complicated topic. We will have recorded this, so if it was valuable to you and you'd like to share it, I will be following up with the link to the recording. And again, thank you all for coming, and have a great rest of your day. Take care.
Thank
Thank
you.
you.
Thank you.